Thank you, Judge. May it please the court, members of the jury. The 11 seconds that it took for me to walk from my desk to this podium is the time span that happened in the time that Mr. Debunking takes to the next door, push up Mr. Drejka from the shot. 11 seconds is all it took. And so I think it's important that when the state tells you, look at that video, absolutely, I'm going to play it in a second. We want you to look at the video. We want you to look at it in real time. We don't want you to look at it in slow motion. Because life doesn't happen in slow motion. Life didn't happen in slow motion for Mr. Drejka. Now there are things that you're going to see in that video, but there are things that you can't hear in that video, but that happened. Things that come into play or came into play when Mr. Drejka took the action that he did in those 11 seconds. And even within those 11 seconds, members of the jury, even within those 11 seconds, it took about 5 seconds, roughly, for Mr. Debunking to push Mr. Drejka, and then another maybe 3 to 4 seconds before the discharge of the gun. 11 seconds. And while Mr. Debunking, may he rest in peace, had no weapon, he was the weapon. He was the weapon. The judge is going to read you an instruction on homicide, on manslaughter. When you hear the term homicide, it means death as opposed to, let's say, suicide. So it's a technical term, medical term. Just the opposite of homicide. I'm sorry, opposite of suicide. Specifically, he is charged with manslaughter. As Mr. Shaw pointed out, it's not first-degree murder, but he premeditated this. So when you hear about this February event, I would submit to you, one, that February event is not a crime. Not a crime. He wasn't even charged with that incident. He wasn't even arrested for that incident. In fact, Mr. Richie Kelly didn't even bother calling the police for that incident. I'll get to Mr. Richie Kelly's testimony in a little bit. So there's no premeditation, so not first-degree murder. No second-degree murder, no ill will. There's no evidence of ill will. No evidence of ill will. No evidence of hatred. And no evidence of spite. Because that would have been the element for second-degree murder. He's not, Mr. Drejka is not on trial for having ill will, hatred, or spite, or premeditation. So that February event, I submit to you, is not even a crime, and the judge will even tell you he's not on trial for that crime. The state wants you to hear that testimony, give you this idea that this was something planned. Something that he planned apparently months ago, meaning Mr. Drejka. Couldn't wait for this to happen. We want you to look at the video, but when we look at it, Mr. Drejka, I want you to look at it in real time. I'm going to play it for a second. Go ahead. Mr. From there. 11 seconds. Stop. Now, what I think is important to the jury is that when the judge reads you the definition of manslaughter, the judge is going to read you the definition, and just bear with me, that there are exceptions. It's an unjustified homicide. Unjustified is the key word. And the judge will tell you, though, there are, within the law, and as the fact finder, we're going to get to what your role as the fact finder means and why it is so important that you listen to these witnesses. Listen to what they say today, but listen to what they also said back then. And as you folks weigh the credibility of these witnesses, if they've changed their story, that's something that you can go back and go take into consideration. Is if we're here to find out the truth, why are witnesses changing their story today? And I submit to you, we'll get to that in a minute, but I'll submit to you, there'll be plenty of instances where these witnesses are changing their story to fit the crime that didn't happen. The judge will tell you that there are, within the definition of this manslaughter, the unjustified killing of another person, there are exceptions. There's justifiable homicide. That's a defense, so to speak. Justifiable is when a person reacts to defend themselves, short of self-defense, we'll get that in a minute, to prevent something like a felony being committed upon them. The judge will also tell you there's what's known as excusable homicide. Excusable is when someone reacts heat of passion, sudden provocation. The judge will read you that law. And that's why it's important when you read or you listen to the testimony of these witnesses, you'll see that there was sudden provocation on the part of Mr. Debunking. The judge will also tell you that the self-defense is a law that's been in place forever. And you folks can take that into consideration when you listen to the facts and when you look at it. More importantly, the judge will tell you that you have to look at what were the circumstances that surrounded Mr. Drejka at the time this happened. In 11 seconds, this happened. In 11 seconds, you'll hear testimony. This is Mrs. Brittany Jacobs right here, coming out of her vehicle. This is Mr. Costelli, and that's Mr. McLaughlin. It's important, Mr. Jury, that we look at this. Remember, it took about 6 seconds from the time that Mr. McLaughlin exited the store and pushed Mr. Drejka. 6 seconds after. And play it. And stop. Now, what you're going to hear is this, that prior to Mr. McLaughlin coming out, Mr. Costelli, the gentleman that you see coming out of the store with the blue shirt and the red sneakers, you're going to hear that he did hear the altercation. It was a verbal altercation. But what's important is you're not going to hear Mr. Costelli say that Mr. Drejka was threatening anybody. No matter what Mr. Schaub or the state says, there was no threats. Mr. Drejka had a concealed weapon. He was allowed to have a concealed weapon. Not once did he ever take that weapon out or threaten anybody. Not once. Never threatened. Brittany Jacobs, who was in the car, never said anything to cause any fear in her mind. Nothing. In fact, you will hear that at some point, Ms. Jacobs said to law enforcement, when all this was said and done, that she couldn't wait to get out of that car. She was going to lay her hands on Mr. Drejka, too. She couldn't wait to get out of the car. And if you look, who opens the door the minute she sees Mr. McLaughlin come out? Brittany Jacobs. Prior to that, Mr. Costelli will tell you at some point in the past, Mr. Costelli told, during an interview, if you will, deposition, that he specifically heard Ms. Jacobs say, "My man is going to F you up." Wait, because my man is about to F you up. So when you hear Mr. Schaub say there was a verbal altercation, absolutely there was a verbal altercation. But not once did Mr. Drejka threaten him or her, threaten the kids. There were kids in the car. We want you to rely not on emotion, but on facts. The facts, the truth. Not once did he threaten anybody, not one. Mr. Costelli will tell you not one word of a threat on the part of Mr. Drejka. He'll tell you, folks, that it was Brittany Jacobs who was threatening Mr. Drejka. Wait, my man is going to F you up. Just wait. And no sooner that he comes out of the store, no sooner does he come out of the store, she's in the car, she sees her man, and what does she do? She comes out. Stop. And so when the judge tells you, you have to put yourself, or not yourself, but when you have to consider all the facts and circumstances that Mr. Drejka was facing at that time, you have to consider that in those 11 seconds, and actually shorter than that, because the push is about to happen, he doesn't see Mr. McLaughlin. He doesn't see him at all. He's blindsided. And for Mr. Schaub to say that this was just a push, this was not a push. This was a violent shove. So much so that when he hit the pavement, you'll see, look at this, you'll see at some point. Look at Mr. Drejka's neck. The whiplash, the force of the blow, and he landed. Jump ahead a little bit. When you hear that there was a little injury, the force was so strong that it tore a hole in his shirt. And during his interview, during his voluntary interview, law enforcement, that he didn't have to give, he had to make a makeshift sling because he had hurt his arm. So at this point, this is a perfect stop right here. So at this point, when the judge tells you, you have to look at the facts and the circumstances that surrounded Mr. Drejka at the time that he reacted. At this point, 1, 2, 3 people are hovering over Mr. Drejka. 3 people. You have the threat that my man is going to F you up. You have her exiting the car, and then you have this sudden shove, this sudden push that caused him to hit that concrete hard. And looming in the background is Mr. Costelli. And in that instant, in about, remember, from the time of the push to the time that the gun was withdrawn and discharged, it's about 3 to 4 seconds. 3 to 4 seconds before the discharge took place. And within those 3 to 4 seconds, Mr. Drejka, in his mind, what is about to happen to me? That I see Ms. Jacobs come out, I've been blindsided and shoved, I see a gentleman looming in the background, and I see Mr. McLaughlin lifting up his pants. I submit to you, Madam President. And that's how they proceed. When you hear all this, absolutely, take all this into consideration. But let's get to the truth. Let's get to the truth of what happened. 11 seconds, members of the jury. That's all it took. And unfortunately, the action Mr. Blockman took resulted in this. I'm not blaming here to assign blame. I'm here to explain. There's justifiable homicide, there's excusable homicide, and then there's self-defense. Those are the facts that we want you to hear. Here's my case. Shooting happens. Mr. Castelli walks away. Mr. McGlynn goes in the store. Mr. Drejka sits there. He pauses. He goes on for a few more seconds after that. He pauses. He puts his gun down. What does he do? He waits. He doesn't run. He doesn't flee. He waits. Who does he wait for? Just for the police. He waited for the police, and he told them what happened. Now, at some point, this is the danger when you talk to the police, is that anything you say can and will be used against you, no matter what you say. So in this instance, because he said, go back, go back, go back, it's not like Mr. Drejka took a measuring tape and measured it before he interviewed with the police. At the time he was interviewed with the police, he had a makeshift arm sling. He's giving law enforcement his best recollection of what happened. So when the police come here and tell you, he said, go back, to the point where law enforcement couldn't go back anymore, and it was happened to be 9, 10 feet, does that make it so? Or is that just Mr. Drejka's best interpretation of what he would call happened? When Mr. Drejka tells you that in the 2 seconds, 3 or 4 seconds that it took for him to shoot the gun, that in his perception he saw Mr. McLaughlin come after him, is he lying? You will hear testimony that Mr. Drejka went into the store and asked, are there cameras, are there cameras, are there cameras? This is immediately after the shooting, because he knew the owners as well. Are there cameras, are there cameras, are there cameras? Yeah, there's cameras. He knew there was cameras inside that store. So he wasn't lying. He was remembering the best that he could for the impact that he sustained. It's important to point out that the state made a big point that he himself didn't park in the spot. Certainly, though, you'll see that this photograph was taken almost immediately after the incident, and Ms. Brittany Jacobs' car is no longer there. Somebody moved it. Somebody moved it just before the police got there. But even more importantly, members of the jury, when we look at the setting, the circumstances, you're going to hear from the medical examiner that Mr. McLaughlin was slightly taller, a couple inches, maybe a few inches taller, weight heavier. And these are things, again, that the court will take into consideration, the facts, the circumstances, the size, the appearance of the aggression that he was faced with that caused him to react the way he did. But the other advantage that Mr. McLaughlin had at that moment was that, not in addition to the height, that he was a height difference. Mr. Drejka was sitting on lower ground, and Mr. McLaughlin had higher ground. And these were all the factors that came into play at the time the incident happened. I mentioned the witness credibility. It's important. It is. The judge will tell you that the presumption of innocence does stay. It's up to the state to disprove. It's up to the state to prove that it wasn't justifiable through the same witnesses. It's up to the state to prove to you that it wasn't excusable. And it's up to the state to prove that it wasn't self-defense. We don't have any burden here, and I have to remind you of that. We have no burden, no responsibility. But in order for the state to do that, you have this awesome power to believe or disbelieve these witnesses. That's why when Mr. Shaw says, listen carefully to his interview, absolutely listen carefully to his interview. The one that he didn't have to give, the one he gave, what they call after his wife. Listen to what Ms. Jacobs has to say today. To compare it to what she told law enforcement that day. That she got out of that car for a reason, not because she was in fear. She couldn't wait to get her hands on him as well. And that's the sentiment that was conveyed to Mr. Drejka. It created this apprehension of fear, a reasonable apprehension of fear, coupled with a threat. Wait till my man comes out. Coupled by the sudden violent push. And then this gentleman, Mr. Castelli, looming in the background. 4 seconds, member of the jury, 4 seconds. That's why there's no premeditation. That's why there's no ill will, hatred, and spite, because it was 4 seconds. 4 seconds, circumstances by which Mr. Drejka felt that something was going to happen. And what's important, members of the jury, is at some point the judge will tell you that the danger need not have been actual. The danger need not even have been actual in his state of mind. It's the appearance of danger. If you take notes, take this note. You don't have to, but just the danger need not even be actual. It's the appearance of danger that could cause him to act justifiably, excusably, or in self-defense. That's what's at issue here. So look at the video, listen to the testimony, and put it all together. Let's talk about Richard Kelly now that I mentioned. And as I mentioned, members of the jury, as far as the slow motion, members of the jury, the state's going to play whatever version they want. Life didn't happen in slow motion. I want you to look at it in real time. Count the number of seconds. Play it in slow motion if you want. That's not how it happened to Mr. Drejka. Going back a little bit, put the circumstances kind of into context. It may have been Mr. Drejka's pet peeve that somebody was parking in a handicapped spot. That's not a crime. We heard from members of the jury yesterday, this week, that said the same thing. It's a personal issue to Mr. Drejka to have someone park in a handicapped spot. That's not a crime. In fact, Mr. Shaw told you perhaps it was wrong for them to park in that spot. And that's all Mr. Drejka did. So in your testimony about him looking around behind the car, you'll see what he's doing. He's looking for a handicap tag. That's all he's doing. So if there's any allegation that, well, Ms. Brickey felt threatened, you can hear testimony, he didn't even know they were there inside the car. One, he had glasses on, and two, the windows were tinted. He had no idea who was in the car. He's looking for a tag in the rear, goes up front, looks for a tag up front, doesn't find anything. And at some point, you'll see that the window rolls down, and it's Ms. Jacobs who initiates the contact, initiates the aggression. He went downhill from there. That is the fact. Those are the facts. That's the truth by which you need to go back and determine whether or not a crime has been committed. You can see my style is a little bit more deliberate. I'm not going to rely on emotion. Because this is important. We're not driven by emotion, politics. We're driven by the facts. So bear with me if I take the time to look at my notes, but this is important. And as fact finders, the judge would expect the same of you. No emotion, just the facts. You will hear that there were other people there. Again, the state has the sole burden of proving guilt beyond a reasonable doubt. There were other people there, and they were actually absolutely watching and observing what had happened. And quite frankly, you'll see that Mr. Castelli was there. You heard he went to the store, and we'll find out maybe what was his rationale for walking. What was his deal? Why was he going out and approaching this altercation, if you will? There was a young lady by the name of Brittany Hicks. She was there. In fact, I think you may see her in the video. She may have been one of the young ladies that looked back, saw that there was an argument going on, but went on her way. Not enough. She didn't see anything that caused her enough to really say something bad's going to happen. It really was just a verbal dispute. And the person who initiated the violent contact, the person you can see didn't have a knife, didn't have a gun. The person who had the force, the weight, he didn't walk over to Mr. Drejka. He made a beeline to Mr. Drejka. He made a beeline towards him. He forcibly pushed him. He initiated the violence. Talk about Richard Kelly. This incident happened in February of the year before. What's interesting, again, is the state's going to tell you, well, he's not charged with that, it's not a crime, and it's not. The judge's going to tell you, he's not charged with that. But you can kind of take that into consideration to see whether there was a motive, plan, something that's going on and working the mind of Mr. Drejka. Well, members of the jury, again, it's not a crime as to what happened back in February. It wasn't a crime. The police were never called. Mr. Drejka was never charged. And so if the state's not going to argue this is premeditation, which it's not, then what's the point of listening to this story? You have to rely on the evidence and the facts that I submit you happened that day. Now, Mr. Kelly is going to tell you that this altercation happened, and that what did he see Mr. Drejka do? Take pictures. Take pictures of this company vehicle parked in a handicapped spot. And what did Mr. Drejka do? He didn't pull out a gun. There was no violence. They're claiming that the statement was made, I could have blown his head off. I'm sure. Again, that's not charged with a crime, wasn't a crime then. No police were called, despite the fact that they want you to believe that he threatened to shoot him. No police were called. What did Mr. Drejka do? He called management. He called the company to say, hey, you can park in the handicap spot. My pet peeve, folks, my pet peeve. And that's all he did, was he called the company. So take a look at Mr. Kelly's testimony, because you're going to hear that coincidentally, he happened to drive by, he saw the car, and he's going to tell you, from what I gather, opening statements, that he didn't know who was shot, who was killed, he didn't know anything about that, just happened to recognize the car, happened to be at the right time, right place, right time, spoke to law enforcement, Detective DeLeon, and said, hey, I recognize that car, and this is what happened 4 months ago, 5 months ago. And then that led to his boss, John Tyler, potentially becoming a witness, but then you're going to hear that Mr. Kelly himself participated in rallies against Mr. Drejka, joined his community to go out there and fight to see that he's convicted. And the judge is going to tell you, you have that right to look at what's the incentive for witnesses to come in here and say what they're going to say. And so this Mr. Kelly, who was out there fighting for the conviction of Mr. Drejka, was out there rallying with the people, and come in and tell you about an incident that happened where he didn't call the police. Important. If we could look at the video one more time, Mr. Flores. By the way, while he's preparing that, unfortunately, that day there was, you're going to hear there's testimony that Mr. Block did have what's commonly known as ecstasy or LSD in the system. And you're going to hear from their witness, you're going to hear from their expert witness that what he, in his expert opinion, believes ecstasy, the effect that that could have on a person. But you're also going to hear from their own expert that ecstasy can cause impulsivity. Their own expert's going to tell you that he didn't know Mr. McLaughlin, doesn't know how long Mr. McLaughlin may have been using LSD, doesn't know anything about that, doesn't know how much he took that day. LSD. But he'll tell you, their own witness, and you may even hear from a witness of ours, that yes.
Your Honor, I'd object. There's no testimony or evidence about LSD in this case.
Yeah, I think you may have said that by accident, so I'll sustain the objection.
All right. Ecstasy, I'll just make, I apologize, not LSD, LSD. Different drug completely. I'm a little older, I apologize. Ecstasy for short, okay. Point is, you can hear their own experts going to say that ecstasy can lead to the impulsivity that submits you. You witness the cause of violently push. And that's evidence. But you're allowed to take that back to root and consider that when you deliberate. Let's talk about this. Okay, so now there's testimony that within the time that Mr. Drejka removed the gun, and it took about 2 to 4 seconds, 4 seconds at best, at most, that he was directing Mr. McLaughlin, directing him, and then he discharged. But remember though, we're talking 4 seconds, we're talking about, and again, if you look at the video, we're talking about the shock, the whiplash, if you will, the force that ended. The shock, and at some point you can hear from Valerie McLean, who can tell you that usually when someone's confronted with that type of violence, usually your reaction is one of shock, especially when you don't expect it coming. A blow like that, there's one of shock, disorientation, confusion. That's what's important, that they won't discuss, the state won't discuss. There was confusion on the part of Mr. Drejka. He had no idea what had just happened to him. He looked at the video, he had no clue that he was going to get slammed the way he did and then collide with the floor. And we've heard it before during the jury selection. It causes confusion. You don't realize what's happened to you. So when there's testimony that he took the gun and started directing people, I submit to you, common sense will tell you, and the evidence will show, it's a little bit of everything, a little bit of confusion, shock, because again, when you see that the shooting's done, at the end of that video, he sits there. Mr. Drejka just sits there. The same position you see where he discharged, and just sits there. I submit to you, in that same state of shock. So this idea of going back to say that he was directing him, which one? You'll see that the quality of the video is not good. Stop, can you rewind it? All right, I want you to look at, you're going to see Mr. McLaughlin exit the store. If you can, look over his right shoulder and you'll see there's some static, because everyone will agree that this is not the best high quality video. All right, push play. Look over his right shoulder. You can see some static, do it again. some static. You can see the hat. And so at some point you'll see, I don't know if you see it was right shoulder. At some point when you see the gun where they're claiming that he's directing someone, you can't rely on what you see in the video, because that video, unfortunately, is not the best quality video. You'll see in other instances the grill of the vehicle, the static. You can look at it in your own time. The static, it makes things look like they're moving when they're not. You just stop. Okay. So when the state says that they're watching this, I submit to you it's a combination of the shock, the nervousness, and this poor quality video. No one's going to ever tell you that on that day, the day of the shooting, that they saw him directing. No one said that. No one's going to say that they saw that happen. There was no time for Mr. Drejka to contemplate that, to say, move. In fact, nothing was even said. And again, remember this whole idea that, well, he saw the legs up. Patel was an African-American person. We get it. It's not about race, but we get it. You got to make it a point. You recognize an African-American male. It's not what happened. It's not what this is about. But nonetheless, for them to sit there and say that all you can see, and yet he claims he learned that, remember, it's not that quick. That quick. There's no time for him to contemplate, to direct anyone. Look at the video, you'll see it's a combination of poor quality video and nervousness. And the time he's confronted with what you see there, the three people moving in the back. All right, you can stop it. I'm going to sum it up this way, Member Drejka. Actually, if I have a moment, Judge, I'm sorry.
You may.
All right, so, and I promise you I'm going to wrap up, but one of the things that, again, I want you to listen carefully to the witnesses, just as a simple reminder, is when you go back there as the fact finder, as the truth finder, the judge is going to tell you that you have to have an abiding conviction of guilt. The judge is going to tell you that. It's an abiding conviction of guilt. That's how strong the state's burden is. That's how strong it has to be. And that's why I implore you, absolutely listen to the testimony, but more importantly, what are people saying now as opposed to what they said back then? Again, you will hear that at some point, it was Brittany Hicks that at some point may or may not testify, and if she does, she'll tell you that she herself thought that Mr. McLaughlin was coming in for another blow, another attack. And again, if you look at that video, at that one point where Mr. McLaughlin lifts up his pants and he has his hands up, that is what Mr. Drejka saw. We can't ignore that. The state may want you to, but you can't. Because that's exactly what went on in Mr. Drejka's mind. So Brittany Hicks is going to say, I submit to you, at least she said back then, that she herself thought that Mr. McLaughlin was going in for another attack. All right. Folks, I know you've been very attentive, and I'm just going to wrap up with the following closing remarks. I'm sorry. This is my opening statement. This is not evidence. I want you to remember the rules, so to speak, is that you're the fact finder. Justice is blind. It's not driven by emotion. Politics, race, prejudice, bias. Judge can tell you that doesn't communicate. The facts. The facts that they represented that day. The facts that they played in the mind of Mr. Drejka that day. I think it is important that when you hear the testimony of Mr. Kelly, Richie Kelly, keep in mind, and Mr. Tyler, his boss, keep in mind the context of what happened then back in February compared to what happened in July. There was no fight, no physical altercation. Allegedly, words were exchanged where he allegedly, my client allegedly threatened to shoot somebody, although no gun. Listen carefully to the testimony. At some point, Mr. Drejka went to his car, and you heard he took pictures. There was no gun removed that day in February, no gun. There's a difference, there's a complete difference of the two incidences that I submit to you really should have no bearing. That's just my argument to you folks. What happened here was unfortunate. What happened here was a gentleman who weighed more, was taller, had the higher ground from the ramp, initiated the contact, and it caused, again, the sense of shock in the mind of Mr. Drejka. I submit to you, the evidence will show that he reacted based on what he observed that day. I submit to you the evidence will show that the use of deadly force was justifiable, and you're going to hear that term again, excusable and so on. Justifiable because, again, Mr. Drejka reasonably believed that force was necessary. And those facts and those circumstances are justifiable. And I also submit to you that his behavior was excusable. The sudden provocation, that you hear the word, sudden provocation, you hear the judge tell you, the sudden provocation that occurred would also rise to the level of excusable homicide. And those are defenses. And it's the state's burden to rebut those and show that it wasn't justifiable or excusable, or the last one, self-defense. Remember, you have to consider everything, the facts and circumstances by which he was surrounded, and I promise I'm going to end with this. When you couple everything you've heard me say, altercation, encounter, the verbal altercation, the fact that not once did Mr. Drejka, when he initiated contact, the fact that he didn't even know that that car was occupied, the fact that he never moved a gun, the fact that it was Brittany who initiated the threats and the warning, my man's going to come in if you will.
Your Honor, at this point, the state would object. We're getting into argument now, repeating the same things over during opening
Judge, I'll
arguments.
conclude. Thank you, Judge. That the only true and just verdict is that of not guilty. And that's what we're asking for. Thank you. On behalf of Mr. Drejka and my fellow co-counsel, I thank you for your time.
All right. Thank you, Mr. Cameron.
Thank you, Judge.
All right, members of the jury, we've been going for quite a while, so let's go ahead and give you a 10-minute comfort break, and then we'll come back and we'll start with the testimony.
Yeah. Is it for lunch break? Yeah. Second.
All right, so we'll take a 10-minute break.